Welcome back, everyone. For this session, we are happy to welcome Jørn, Sunde, and Anna Sanders, who will talk to us about the principle of the child's best interest and how do national apex courts apply this principle within a diverse legal, cultural, and political context. Jørn is professor of legal history at the University of Oslo, and is also affiliated with the Department of Government at UiB. And Anna is professor at the University of Bielefeld in Germany. So they will talk for 30 minutes, and then they will be joined by Lisa Søreide. So Lisa is a judge at the Hordaland District Court, and she will comment on their talk and also share some insight with us. And then we will open up for questions after that.
Thank you very much. Thank you for inviting us to give a speech on the best interest of the child in national apex courts. And we are going to have what I would call a legal methodological and legal cultural approach to this issue. So first of all, this is a part of the entire project, and we started out with an already somewhat existing research design, and that Anna Cortes had already collected quite a number of apex courts decisions and also literature from different countries in the world concerning the best interest of the child. So when Anna Cortes is not here as a part of the project is because she's in a maternal leave. What we've done is, though, to make a test research. So this is not by any means a fully comprehensible research on the topic, but we chose decisions from the courts of Germany, Portugal, Ireland, United Kingdom, and Norway, and we've done a study of them to see how this project might be developed further. And one of the things that we did discover is, of course, that when you studied court decision from apex courts, not all apex courts are the same kind of a court. So in some countries, the apex court is a Supreme Court, in other countries, a constitutional court, and there are some differences between them. So that is a methodological flaw in our test research. We'll admit that. But we still think that our findings is valid. So, I am Jørn Øyrehagen Sunde, professor at the Department of Public Law at the University in Oslo. I'm a legal historian, but my specialty is legal methodology in history and legal culture. So that's why I feel able to do this kind of research.
My name is Anna Sanders. I have a chair at the University of Bielefeld, and I work on a couple of things, but I also work on family law and constitutional law. So, for example, I wrote a book about multiple parenthood relationships, so situations where one child has more than two parents, and what happens there and how this should be regulated. And I've also worked as a law clerk at the German Constitutional Court, and that's why I can talk about how they work there a little bit.
And we're going to make what we've called a tandem lecture. So we're going to speak on each slide, both of us. There's 10 slides. We have 30 minutes. That's 3 minutes per slide and 1.5 minutes per person per slide. So that's about what we're going to do. So, first of all, when we'd read apex court decisions from Germany, Portugal, Ireland, United Kingdom, and Norway, there was a striking observation. There was a very difference in how these courts were dealing with the best interest of the child.
Yes, and I start with that you can group German, Portuguese, and more or less the Irish court rulings, and their main feature is that they follow rights and interests-based approach. So they look at the best interest of the child, and then they make they balance interests. So they look at the public, and they look at the family and the rights of the child, and also the the rights of parents, and when the state intervenes, then there's always a sort of balancing. What is the state allowed to do to protect children? What is the state allowed to do in the interest of parents? So you have this interests-parents balancing approach.
Now, most of you don't think, isn't that what all apex courts would do? We're actually talking about the best interest of the child. But if you read a German or Portuguese decision, interest is a word which is occurring again and again and again, because you're talking about the interests or rights and balancing them. If you read a UK or Norwegian Supreme Court decision, interest is a word that doesn't occur very often. And if it occurs, it's only the interest of the child. Almost never, the interest of the parents. It is because UK courts and Norwegian courts has a different approach. They're not balancing rights or interests, but they're actually looking at the very facts. What is the factual situation with the child in the family, and now that she's in custody, outside the family? So it is a the proportionality is about a proportionality between factual situations, more than between rights.
While in the German, Portuguese, and Irish courts, it's more the proportionality between different interests.
So where does this difference start? I would say it starts in the 17th century with natural law thinking. And natural law might not be familiar with you, but this is the pre-runner for the human rights thinking, which the best interest of the child is a part of. But more important than just these ideas of rights that occur in the 17th and are developed in the 18th century is the methodology that you treat rights with. So the dominating methodology on the continental Europe is that you go from wide rights to more narrow rights, and finally you deduce down to the legal rule. This methodology, which is then the way that most lawyers in Europe reason by, was never really accepted in the UK and in Scandinavia. And I say Scandinavia, not the Nordic countries, but because Finland is an acceptance. They do it the continental way. So, so this methodological, terribly difficult word, approach might be a reason why we reason differently about the best interest of the child.
So then another reason why we might reason differently here is that then we need to sort of go on in history, and really what we most of us now consider sort of the human rights litigation or human rights tradition in Europe now really starts after World War II with the end of autocratic rule in many countries, with constitutions, with long human rights catalogs, and constitutional courts, very powerful constitutional courts. I come from Germany. The German Constitutional Court is a very, very good example for that. Also because, of course, it was established there after the most horrible time of human rights violations you can think of. But this is not autocratic rule and human rights violations in this respect, weren't, of course, not limited to Germany. Italy, Spain, and Portugal here, they have their own history, traditions, and history with autocratic rules. Salazar in Portugal, Franco in Spain, and Mussolini in Italy, of course. And I think something that we should take from that is that in these countries, there's still a lot of awareness of the fact that the state is not always your friend. And in Germany, for example, when we look at human rights and best interests of the child, there we had a strong tradition or a history that is still very vivid of the state pressing families, pressing children into state organization, the Hitlerjugend and the Bund Deutscher Mädel, and in the Eastern Germany, of course, all these youth organizations there. So the state is not necessarily the friend of peaceful family life. And this is a tradition we have to keep in mind when we want to understand these kind of reasonings the courts do now.
So when we talk about why are we treating the best interests of the child differently in different courts in different European countries, the cultural argument always emerges. What we should then be careful is talking too much about culture in general. Because at least I've tried to show you how this is a cultural model which is very accessible on the internet. It is not strictly scientific, but it is used also in academic settings. If you want to, you can try just, Google model of the cultural factor group, and you can test out if you agree or not with the model. But I tried to compare here Germany, Norway, Portugal, and United Kingdom. That's only possible to compare 4 countries, not more, unless you pay, and I didn't. But if it was cultural factors, just in the wide sense of culture, that made Germany and Portugal treat the best interests of the child the same way in apex court decisions, they should pair up here, and they don't. As you will see, there is actually no clear cultural pattern, at least in this very simple test. That doesn't mean that culture doesn't play a role, but we have chosen to focus more on what I would call the legal culture. So legal culture is, of course, very much linked to the general culture, but it can be much more specified. And there are some interesting differences between Germany and Portugal and England and the UK, with Ireland in between, that might be useful to look at to explain the differences in how the best interest of the child is treated in apex court decisions.
Yeah. Then, of course, we come up to what we usually or often call the sort of civil law, common law divide, with, of course, the UK, England mainly as a sort of motherland of common law. And Norway is in these kind of discussions usually placed sort of in between or quite close to a common law country. And then we have in the more civil law tradition that Germany and Portugal adhere to, we have a sort of legislation. Legislation is very important, while we have a precedent, of course, a rule of precedent in common law countries. We have a sort of we stress the theoretical hierarchy of norms, sort of with the constitution on top and that. And we have codifications and put very much importance on that. Of course, you always have to take all these arguments with a big pinch of salt, because, of course, we have, at least in Germany, for example, we have very old codifications by now, so precedent becomes more and more important. So this is not as easy as it sounds, but we have to break down things a bit here. Then, of course, in the legal methodology, we have a difference between deduction. In the civil law tradition, you deduce from general principles, while in the common law countries, you have more of a kind of fact-distinguishing approach. Then I think this is a main thing, a thing that Jørn and I think is very, very important, who actually makes decisions in court. And we think this is very important because, of course, people are educated judges, they're educated in different traditions, and the person who makes the decision is actually sort of at the center of the whole discussion here. In civil law countries like Portugal, like Germany, you have the judge is a civil servant. He or she is someone who started their job as a judge very early in their career. It is someone who graduated from law school and then became a judge very quickly. So this person is socialized within a bureaucracy of judges, basically. While in the common law countries, you have people who become judges rather late in their career, like also in Norway. And these are people who are socialized outside the judiciary. They have a career on their own, they bring in their own and very diverse ideas with it. That's why we say, well, a barrister with a wig, but a barrister who had very different cases beforehand. And one hand, we have a lifelong service for the state, and then we have ending the career in it. And we think that these differences are quite important when we want to understand the differences between courts.
Because if we link this to what Anna said about autocratic rule, it is in countries with an autocratic past that you also find the judge linked to the state as a civil servant, while in countries without such an autocratic past, you find that the judges do first service in society and then becomes a judge and then into the service of the state. And hence, if you have a distrust of the state, that distrust will also be linked to the civil servant, while if you don't have a distrust to the state, you ensure that the state is not evil now that the servants are coming from society that you share with them. That's, yeah.
Okay, so now I want to talk a little bit about, the line of argumentation in German and Portuguese court rulings, and sort of like want to show you a little bit about, how this kind of balancing works actually, and how this is done. This picture here on the side is something I use when I teach family constitutional court in German law school, and you see, of course, they have German terms in it. On top you have the state, then you have Eltern, which are parents, and then you have the child, the Kind. And you see that actually sort of the parents and the child, they are both right holders, they're both independent right holders, and they have rights against the state to respect their human rights, and also these hands, they have the right to be protected by the state. So the child the state has a duty against the child to protect it, and the child has also a right that the state stays out of its private life, and the parents as well. And the state, given that the child is sort of still developing, still needs support, and is developing, needs support against the parents, the state has the duty to sort of supervise the child-parent relationship and to step in if there's something going wrong there. But you see, this whole thing really means that if you are at a constitutional court deciding these cases, that you have to balance, if the state steps in, the state has to justify this intervention, and you balance these interests against each other. And the ECHR, of course, then works, if the ECHR hears a German case, they work on the basis of what they see here and build on that. And the interest of the public here, in a way, comes then through this sort of supervising role of the state.
That is interesting, because if you read a German or Portuguese apex court decision about the best interest of the child, you have a mentioning of the best interest of the child, the best interest of the parents, and the public interest. And that means that public interest and the best interest of the parents, they pair up. It becomes two interests against one.
Well, and maybe one thing too is that given that the best interest of the child, if the question really is here, who defines the best interest of the child? And under this model, the best interest of the child is primarily defined by the parents. The state steps in for the best interest of the child with an objective perspective if the parents are out of line. But the idea is actually it's the freedom and the duty of the parents to take care of the child and in a way develop the best interest of the child within their family.
So, in the Portuguese and in the German constitution, there you have provisions on the best interest of the parents and the best interest of the child, both. What is interesting, and is pure logic, is that in the Constitution you first treat the best interest of the parents. It is purely logic, because if you don't have parents, you don't have a child. But it becomes, when you're reading the Constitution, that's the line you follow. What about the parents? What about the child? In that order. What about UK and Norway? There is no, well, the UK has no modern constitution. It's a constitutionally extremely complicated country with many constitutional documents, the oldest being Magna Carta from 1215, which I can assure you doesn't have anything about the best interest of the child at all. So does most of the other constitutional instruments in the UK, because the protection of the child is in England in a statute called the Child Welfare Statute. So it's on a statute level. What about Norway? In Norway, the best interest of the child has been added to the constitution. But if you look at the Norwegian constitution, family is mentioned 6 times. 5 times is about the royal family. Which usually doesn't apply. At least the case is not going to get to the Human Rights Court, I'm quite sure. No, it's the 6th time that family is mentioned, and it's in relation to the best interest of the child at the very end of the rule. So it's not given any priority or any very prominent position in the Norwegian constitution, the family. That is the starting point. And when we were reading these cases, Anna told me, in this English case, is there something missing? There's nothing about the parents here. Now, it wasn't missing because in the UK courts, they do not discuss the interest of the parents. Often they don't in the Norwegian courts either. Because it's not, as I said in the beginning, a balancing of interests. It's a balancing of factual situations. So when the family is mentioned, it's about how is the child doing in the family and outside the family.
Maybe I can step in here to clarify something. If we say sort of the parents have their own interests, of course, it's not like we in like German courts say, well, the parents are so important and the child is not. The idea is that the parents are really the trustees of the child's best interest, and that they have a role of a trustee to sort of develop their interests. But also German courts accept that somebody must define what is the best interest of the child. And if it's not the parents, it must be the state. So the idea is that if the state defines what the best interest of the child is, it might be defined as the Hitlerjugend. But it's not the idea that the parents define it and actually we don't care about children.
And public interest is not discussed in UK and Norwegian decision. There is something underlying there, and that is that it is in the public interest that parents don't abuse their children, but it's not necessarily spoken out as any consideration. Now, what about Ireland? Ireland is the perfect in-between case. So UK and Norway has not experienced autocratic rule, so has Portugal and Germany. Ireland has also experienced autocratic rule, but by England, so it's a kind of a paradox. But that means that they made a constitution, so they have a constitution like Portugal and Germany, a quite modern constitution, but they don't have a constitutional court because they're still very much, when it comes to the legal system, they're very much linked to the English tradition. So they're very much an in-between country. What is interesting with their constitution is that they, as Portugal and Germany, have provisions first on family, logically, and then on child. And they discuss the best interest of both parents and the child in the court rulings. But they're not talking about public interest, they're talking about the common good, which is pretty much the same thing. But they have defined the common good as something different. That is, the common good is that it's the interest of the common good that the child is educated and get a proper upbringing so it will be a functional citizen. So it is actually two interests pairing up against one, but it is the interest of the child and the common good against that of the parents. So it's a different weighing of the interests.
Yeah. Okay. So we have had a short look at the ACTHR and sort of about how they do that. And the problem here, of course, is that they hear cases from these different countries and that they have a look on those, and that they need, in a way, to sort of deal with these very different legal traditions and ways of argumentation. And so what the court does is, in a way, bridging these principles. I mean, sort of course, they apply a human rights catalog, so that's something you should know from a kind of constitutional system. But on the other hand, we don't have any sort of we don't have a legal system with codifications and so on the ECTHR can build on. So it's very much a precedent-based system what they do. So they in a way, it's a sort of in-between court, one could say. They apply, of course, their catalog of human rights, but they also sort of basically decide themselves and their own cases. And we think that's in a way, that's why they use a kind of sort of combination of methods of deducing from principles, but also looking at cases and distinguishing facts and distinguishing ideas. And something that we would like to stress also is how the importance of the people deciding these cases and working on these cases. They come from different traditions, they use different methodologies, they have different legal educations. And we would also like to underline that we have people here, that we not only have the judges. If you think of the ECTHR, don't only think of judges, because the cases are very much prepared by the law clerks, by the staff working there. And these people are there for a lifetime, while the judges change after 9 years. And they come, the law clerks, people preparing the cases, they are very deeply socialized within this court, and while the role of the judge here is usually to explain their national systems to the other judges and the law clerks, the work of the law clerk is basically really to work within this human rights tradition and develop that further.
So when Norwegian lawyers and researchers are frustrated about how the human rights courts treat Norwegian cases, it is difficult for them to read in the very treatment of the Norwegian cases, why they're thinking differently from Norwegian lawyers. Because we, as the continental lawyers, both find what we're looking for in the human rights court's decisions, because they're using both methods. So we can recognize the reasoning, but not really understand what's behind it. And that's what we've been trying to explore today. So what are we going to do in the future? Because this is just a test study. We want to, of course, expand the number of decisions we are looking at. We want to expand the numbers of countries of which decisions we're looking at. We want to also do some sub-studies, because do the constitutional courts, for instance in Germany, treat the best interest of the child the same way as the Supreme Court in Germany do? Because Supreme Courts and constitutional courts have slightly different roles in a society. So that's one thing we want to do. We also want to do some legal historical research. Have there been a change over time? And lastly, what we also want to do, which is very ambitious, we're getting more and more ambitious, more and more work. Lastly, what we want to do is to look at, if we compare first instant courts in different countries, do we see the same difference as in the apex courts? Our hypothesis is not really. I think these legal methodological and legal cultural aspects becomes more pinpointed at a high peak in a legal system than at the very bottom. But that's a hypothesis. We don't know, but this is what we want. This is where we want to go after this test study. And I think we've been very good, because we kept within our 30 minutes. So thank you.
Thank you for a very interesting and, I must say, thought-provoking presentation. It's given me a new perspective on my own craft as a judge, especially how I interpret and apply the principle of the best interest on the child in child protection cases. Really. As a starting point, I will, to put it simple, as Jørn mentioned earlier, in Norwegian law, we base our decision in child protection cases on decisions on the facts as they stand on the time of the judgment. What is the situation for the child? And from there we must assess what will be the best solution for the child going forward. I will focus on how I as a judge think. I will sort of invite you into my brain, to my brain. It's my brain. I'm not necessarily representative of all Norwegian judges, but I think this will be useful to understand the Norwegian way of thinking, and I think hopefully this will be relevant to issues we have been treating earlier today. And I'd like to start my comment by clarifying a few basic and fundamental principles that guides the court's assessment in child cases in Norway. And these are really, really very important. And from there, I will touch on both the immediate evaluation we make and then the forward-looking assessment that are required. And through this, I hope to highlight, as a comment to you, that even though Norway may approach the best interest assessment differently than other countries presented, I don't necessarily think the outcome of our judgment is all that different. Now I will turn on to the fundamental principle. And this, like I said, for me, this is very important to understand how we think. When I assess whether a child should be placed in public care, my starting point is always this: the child should live at home with the family. The state should not interfere unless there are strong reasons to do so. So what I'm really evaluating is whether an exception should be made to the fundamental right to family life. This way of reasoning, where the starting point is the presumption of family life and the assessing whether an exception is justified, might partly explain what you have noted, that this can be absent in our judgment. That the right to family life sometimes impair in Norwegian judgment. It's not that the right isn't considered at all. It's simply embedded in the legal framework. The question isn't whether the right exists. After all, the right to family life is a fundamental human right. The real legal question is whether it can be lawfully set aside in the child's best interest. And then over to something that is more important for me, and I think also to what I've heard today, and I think also for those of you who are doing research on this. The child's right. What makes children so special? I often think that everybody who is working with children should ask themselves this question. Why do we act in the child's best interest? Why do we have rules about this? And the starting point for this is fundamentally human rights are inherent to every individual. I think what was said is all about dignity of a person. That's what it is. And children, like adults, are right holders in their own right. It's as simple as that. For me, it's obvious that children are individuals, that they have human rights. And this is clearly also, like been pointed out before, stated in Article 1 of the European Convention on Human Rights. It says everyone is protected. Because children then are independent legal subjects, it would be wrong to treat right to family life and the child's best interest as two equal interests to be balanced. For me, this is totally wrong. The child's best interest must always be decisive. We cannot act against that. And then there is something very unique about childhood. And this is very basic in a way, but it's so important. That's why we have rulings about the child's best interest. A child's brain is still developing, and our responsibility is to give each child the opportunity to become the best version of themselves. Giving a child a chance to grow into the best version of themselves is really the core reason why we treat children differently from adults. And to make that possible, children are completely dependent on having a stable care environment around them. They cannot be on their own, and one that can meet their needs and support their development in the best possible way. And it was once a professor from Netherlands who pointed it out so nice. There is so much at stake when it comes to childhood. And as a judge, I see this, unfortunately, over and over and over again. I see the results of the childhood. I see the child in the adults. I see what the bad childhood, to put it that way, does with people. So it's a lot at stake when it comes to childhood. And it's been mentioned further, Norwegian Child Welfare Act. For those of you who haven't read it, I would strongly recommend that you read Chapter 1, which outlines the law's purpose and fundamental principle. It's a brilliant law, to put it that way. Now to the actual assessment that we are making. As a judge, I must consider all relevant circumstances at the time of the decision based on the specific child. And I was hearing of this very interesting lectures from, I think, Larissa and Camilla about it was heartbreaking. But I think that method is very good, because then you look at the circumstances. How does this individual child live? What is special about this child? That's the basis for my assessment. And in this assessment, the child's view and right to participate are crucial, really crucial. After all, the child knows its own situation best. And to take this starting point, it's like somebody said, then you deal with the real life in the real manner. You look what is the actual situation. And that, again, is what human rights are for. Who is this individual? What is this individual standing in, to put it simple? And then the forward-looking evaluation. In the forward-looking assessment, we must evaluate all available alternatives. And the presumption that children should grow up in their families remains a strong argument. But then, as somebody mentioned, what is family today? I went on a convention about modern families and buying eggs and donors, and it's like what is the family? I already at that point, I think starting with the right to family is difficult, and like one said, a child can have many families. The child's right to stay with a foster family if the child prefers them. So it's a presumption, but it's not an equal interest to the best interest of the child. And after a concrete evaluation, it is the child's best interest to be placed outside the home, then that must be by decision. That's how I think. And to sum up, for me, like I said, it's a mistake to frame the child's best interest and the right to family life as two equal rights to be weighed against each other. Put simply, I'm not deciding what is best for the family. I'm deciding what is best for this particular child. And finally, I'd like to share some personal takeaway from your presentation. I found it especially interesting to hear the observation that the European Court of Human Rights speaking differently to lawyers from different traditions. And that, combined with what we had before lunch, really made it clear for me, because it's something that I can't really get from what they are saying. I think it's difficult. Mm-hmm. They have done a good job in changing the system in Norway. We really needed that, but what the legal guidelines are, I have problems with that. And it reasoned with me, especially what you are saying, that the different approaches we take from the best interest of the child. I also, one thing I might change is that Jørn said when we talked earlier about minorities, and in Norway we are privileged. We have a very trust in the state because we have a state who's been okay with us, we trust them, but having minorities in court or people who come from other countries where the state is not good, I might consider writing more about the right to family life, even if it's what the main guideline is. Yes. And then just I would like you to have some research if like I said, is our outcomes different? That would be very interesting to know. Thank you.
Thank you so much, Lisa. I don't know if you have immediate response or.
I would have a short response, if I may. Thank you so much. Thank you so much for letting us into your head. I really appreciate that. And I must say, starting from what you just said at the end, our outcomes, are they so different? I think if we look at if we look at the courts that really deal with the children that are really there, I think my friends, my German judge friends who are on first instance and deal with children and parents, these situations where the child is in danger, where these things, I think they probably make the same reasoning you do with, what is the danger for this child? Is this child in danger? Is this, but of course, and the in-between cases, they're of course the hard ones. I remember a case when one of my friends told me about a mother was a bit crazy, and she had a flat, and everybody coming into the flat had to disinfect themselves because she was crazy about viruses and she was afraid. And of course everybody said, well, this is not very nice for the children. They have to change their clothes when they get in and out. But they really loved their mother, and the mother was very kind and a very loving person. And so, of course, the judge thought, okay, the mother is crazy, but if we give this child to a state institution, that will not be good either. So these are the sort of difficult cases where you really have to, and I'm sure you make the same ideas. Well, what will do this crazy? And I'm sure in these kind of situations, they're quite close. But on the sort of top levels, when the apex courts or when the European Court of Human Rights, when they have to make all these sort of, then we really think about how to weigh certain aspects, I think.
Yes, I think we can now open for questions.
Would you like to answer the first question, or?
Yes, I would like to say a little bit. I think, yes, I mean, the best interest of the parent was a slip of tongue, I think.
And it was probably my fault.
Yes, that's what I try to clarify. It's not about, what's best for the parents, but it is sort of seen as their freedom as parents to define, when educating the child, to define what's best for the child. And then the question of, if the state thinks, the state represented by child services thinks this is not the best interest of the child, what can the state do to change it? Yeah. Then what you say, yes, I think then sort of when you take away things and sort of beside these sort of clear-cut cases, what will you leave with the parents? They're really the questions coming up here, of course. And when we talk about adoptions, for example, we have lots and lots of children who have been taken out of families, and they live for 10 years with foster parents because adoption away from biological parents is not an issue, or very, very, very hard in Germany. Yeah.
And then the hypothesis, our hypothesis is the same as yours. First level courts is probably going to be very similar across different countries, which is going to be an interesting finding anyways, even though it's what we assume. It will be good to have that stated. But second, I don't think I agree when it comes to you cannot decide the best interest of the child only on the facts. That is basically what you do in the UK and Norway. It's a very, very different approach, and it is a long historical traditions for not trusting terminology. Terminology is just meaningless. It is only a question of the facts. Of course, we're pinpointing things. The differences are not that large because in the German and Portuguese decisions, they are also facts. But they're discussing rights primarily, and the facts are linked to the rights, while you're discussing facts, and from there you might derive rights. But it is a different movement. So that was the point. Yeah,
maybe just one point about that. Maybe in this case it might be interesting, at least in Germany, that very many good family judges have been law clerks at the Constitutional Court. They have worked in constitutional cases, first instance cases, applying constitutional law on actual family cases, and that's why a lot of rights discourse is coming in first instance decisions in Germany as well. Sorry.
And then to the question about, do we see lobbying groups? Not in the decisions we've chosen, but the sample is too small. And we'll take that on to the wider research to see if third parties are intervening and if there's a development over time. And the second question was, does the kind of welfare system around parents and children actually matter? Again, the sample was too small, but I would be surprised if it didn't.
Yep.
But I don't have a certain answer.
I do have an answer in a way that from this right approach, at least in the German developments, there were rights to social services deduced. For example, there's a very important case that there were some said two parents, and they were mentally in a difficult situation. And their child was taken away from them, and the Constitutional Court said, no, you cannot take the child of this family. First, you have to give the proper the services to the parents that they can take care of their child properly, because they have the right as parents to do so. Only if this is impossible, you can take the child out. So in a way, it creates a right to social services.
Please. I can just make a very short concluding remark. This was a kind of a test research, and we've got wonderful response. It gave us a lot of ideas what to look into when continuing our research. So I think I'll just conclude by saying thank you very much, all of you.